Good morning, everybody. Welcome to today's ACC Minnesota webinar on outsourcing to India, really touching on current issues. My name is Kent Shane. I'm a member of the board of directors for the Minnesota chapter of the ACC, along with co-chair of the education committee. I'm the general counsel for a startup called TradeUp, and just really happy to introduce today's event. A couple housekeeping notes. To participate today, please submit questions by typing them into the questions pane of your GoToWebinar control panel. Our speaker is going to attempt to answer your questions, but near the end of the program, after he's gone through his prepared material. But you can submit your questions at any time during the presentation. Please note the slides are available as a handout. You can download them from the control panel. One standard CLE is pending in Minnesota for this program. The CLE code is 425403. That code one more time, if anybody's taking it down, is 425403. It's now my pleasure to introduce Mr. Neerav Merchant of Majumdar & Partners. He has over 22 years of experience in all kinds of, his experience covers the spectrum: dispute resolution, litigation, enforcement of foreign judgments and awards, asset recovery, technology, telecom, IP. You get the idea. Also notably, he's one of us. He spent a good amount of time in-house at the GC, and he gets some of the balancing act between business and legal that we all deal with every day. So he's a noted speaker, has spoken at all kinds of forums, and we're really happy to have him with us here today to talk about, again, outsourcing to India. So Neerav, why don't you go ahead and take it away? Thank you.
Thank you, Kent. Thanks for that lovely introduction. Firstly, I would like to thank ACC for organizing this webinar, and I want to thank to all the colleagues and all the professionals who have taken out the time to attend this on a Tuesday busy morning. So before I jump into, the topic is quite exciting. What are the current issues when it comes to outsourcing to India? So before I jump into my main presentation, I just thought I'll give a very brief overview to all the colleagues as to what am I going to cover. So mainly I'm going to cover issues which we relate to on a day-to-day basis. So what is Digital India all about? What are the various models for outsourcing business into India? Then we are going to talk about e-commerce activities in India and what are the regulations and laws that kind of govern e-commerce activities. What are the liabilities of intermediary entities which facilitate a business of e-commerce activities? Then we are going to jump into the regulations relating to other service providers. So, and thereafter we'll talk a bit about data privacy laws and the proposed data protection law. Then we'll speak about various nuances which have been introduced by the Indian government in the last few years, be it data center policy, be it respect to the IPR related issues. And then we'll conclude our discussion on a little bit of competition law. So I have tried my level best to cover a lot of issues here, and I will just kind of start my presentation. So basically in India, this is just a kind of an overview about what has really happened to Digital India in the last 2 decades. So the Indian IT sector has had a stupendous amount of growth, and consistently it's been growing for the last 2 decades. Almost we have touched foreign direct investments to the tune of $74 billion starting April 2000 until June 2021. If we just look at the IT services and the business process management services, the revenues that India clocked, or the IT industry rather clocked, in the last financial year was to the tune of $194 billion, and this is estimated to touch roughly $350 billion by 2025, which is insane. And if we look at foreign direct investments being made into computer software and hardware sector, so if we just do a comparative analysis of Q1 of financial year 2021, in this quarter, in the current quarter, this number has grown by 3 times. And if I have to just walk you guys through with the recent deals that occurred in India, especially in the IT space. So, KKR and company, Facebook, Google, cumulatively kind of invested roughly $13 billion into Geo Platforms Limited, which is an offshoot of Reliance Industries in the telecom vertical. So that is the kind of investments that India has seen even during the peak of the lockdown. And then these investments happened actually last year when practically the entire globe was under lockdown. Thereafter, there was another deal which is quite significant. A Dutch company, operating in the name of PayU, acquired a controlling stake in an Indian private limited company by taking the stake at 185 million US dollars. So, I mean, the long story short, as far as Digital India is concerned, the government of India is trying to transform India into a digital and technological kind of landscape, and so that it can push the initiative of incentivizing businesses for research and development and IT services. My second slide speaks about various models for which typically foreign companies, more so US companies, may use with respect to outsourcing services into India. And I have discussed each of these models slightly more in detail in the next few slides, but this gives you a kind of a snapshot that the most common model which is used for outsourcing services in India is the third-party outsourcing, which is typically the vendor agreements or the IT services agreements, and then this is mainly preferred by businesses which are not expecting to do businesses which are doing non-core activities in India. The second model, which is often considered, is to establish a wholly owned subsidiary in India. This is mainly preferred by businesses who have a slightly longer horizon, a longer viewpoint about India, and they want to kind of carry out either research and development activities, or they want to carry out some core development activities. So in addition to having the option of setting up a wholly owned subsidiary, a particular business may also consider setting up an entity by way of a limited liability partnership, which was introduced in 2008. So it all depends about what is the structure that one wants to adopt, whether one wants to come into India through a wholly owned sub or through a setting up of an LLP. The third quite famous inbound model has been the BuildOperate Transfer model. This has been quite encouraging from a tax perspective, as well as from also for businesses who have not had prior experience of India. So in this particular model, typically what happens is a foreign entity would engage with the vendor, and the vendor would build and operate a certain business for a given number of years. The option is always with the foreign entity to buy out or transfer the entire business as an undertaking at any given point of time. And this is preferred for entities who do not have much experience of doing business in India. So this is fairly kind of a old model which has been used over many years. As I mentioned, each of these models I'll quickly discuss slightly in detail. So third-party outsourcing, it actually involves a vendor agreement between the foreign entity and the Indian vendor. And it is pretty much an independent business relationship established between the two entities. But what one needs to be a little bit careful about is, especially because there's a lot of intellectual property, a lot of confidential information which would travel into India. So the foreign entity is expected to be a little bit more careful while entering into this arrangement with the vendor. This is typically, as I mentioned earlier, this is typically for those entities who are not seeking to do a long-term presence or not seeking to have a long-term presence in India. There are three key issues which I could identify and which could be helpful from a structuring point of view. One is, as I mentioned, confidential information, non-disclosure agreements, etc. But in addition to that, protecting IPRs, especially IPRs which would be kind of shared with the Indian vendor. So in an outsourcing agreement, protection of IPRs becomes quite critical. And that brings us to the question of having a very robust alternate dispute resolution clause, because it's a cross-border contract. So one needs to be quite clear about the governing law and the procedural law and the substantive law of the contract before the contract is executed. And one has to also be mindful that most of the foreign judgments, I think I can count on the tip of my finger, hardly 6 or 7 countries are such whose foreign judgments can be enforced in India. So mainly because of the reciprocity. So India is not having a reciprocity agreement with US and many other European countries. So when you choose the governing law, substantive law of the contract, one has to be slightly more sharp as to if that particular judgment has to be enforced into India, what would be the most preferred law that one can keep in mind for your respective outsourcing contract. In a wholly owned subsidiary model, this is just giving a slight overview about, as I mentioned, the private limited company or an ICO is established under the Indian Companies Act, which was introduced in the year 2013. And this was superseded by the earlier Companies Act of 1956. One could also consider setting up of an LLP in India, which would be under the Limited Liability Partnership Act of 2008. So this, I'm not going too much into detail. This is frankly would depend on the end objectives of the entity and what would work best from a tax perspective, from an operations perspective, and then also from a management perspective. Very basic Indian company established needs to have a minimum of 2 shareholders and then 2 directors. But the catch is one of the directors has to be a resident Indian. So you could have 1 foreign director and 1 resident director in India. And the same goes if you're setting up a limited liability partnership. So the 2 designated partners, out of which one could be a foreign designated partner and the other could be a resident designated partner. Once you set up an entity in India, obviously you need to get going with your operations. So typically a wholly owned subsidiaries would prefer to either acquire real property for office or for factory, etc. And there are 2 main ways in which one could consider doing that. One is the Indian entity would acquire either the office or the land and then set up a factory. But in doing so, title due diligence becomes extremely important, more so because India does not really have all the land records synchronized and kind of assembled in one place compared to some of the countries in the West. So one has to be slightly vigilant about title search diligence exercise. Also, the conveyance deed, which actually transfers the ownership of the land or the office into the Indian entity, has to be registered because until it's not registered, the title wouldn't get conveyed. Similarly, when you enter into a long-term lease agreement, which exceeds for a period of 12 months or more, even that agreement needs to be registered so as to create an interest in the property. Two issues which really came to my mind whilst making this presentation, which a wholly owned sub should keep in mind is, especially when an Indian entity engages or has a contract with its foreign parent entity, typically transfer pricing issues do kind of surface. So that is something one has to keep in mind whilst doing a services contract with the US parent or a foreign parent. And the three main laws, depending on which industry a particular entity is kind of engaged with. So employment law is something similar to many other countries, like India does not. India just has a few employment laws which are federal in nature. Otherwise, most of the employment laws are quite state specific. And so environmental laws, again, depending on the industry one is entering, has to be kept in mind along with many other regulatory laws. So the kind of a compliance structure would go slightly more robust in setting up a wholly owned subsidiary. The third structure which I have identified is the BuildOperate transfer model. So this is a very important structure which one can keep in mind if you have a long-term view on India. And what happens is once the business becomes operational through the Indian vendor, the foreign entity typically has to think of what would be the best suitable structure for transferring the entire business to itself. And in doing so, I think two popular models kind of show up. One is the share purchase agreement, and the other one is doing a BTA, which is a business transfer agreement. And we'll just discuss very quickly about what are the pluses and minuses of both these models. So under the share purchase agreement, typically if the buyer of business is a non-resident or a foreign entity, the foreign direct investment policies would kick in. And again, it depends on the sector, it depends on different parameters. The second thing which one should keep in mind is about the enforceability of non-compete obligations in a share purchase transaction. It's quite difficult to kind of enforce non-compete obligation under an SPA. Successor liability cannot be excluded. It's a very important point that in a share purchase transaction, one cannot really exclude the liabilities of the prior company holding those shares. And finally, the tax consideration. So there is a capital gains tax liability which could trigger under the Income Tax Act. There could be a stamp duty implication, and stamp duty, just for your reference, is a state-specific duty levied on any instrument. So any agreement which attracts a transaction, stamp duty is levied, and every instrument or an agreement would attract a different percentage of a duty. So typically for a share purchase agreement, the duty is 0.015% of the total consideration. Luckily, GST or the goods and services tax would not apply to a share purchase transaction. When I spoke about the capital gains tax liability, I think if the concerned foreign entity has a double taxation avoidance treaty with India, and that could be explored in terms of either eliminating or reducing the capital gains tax liability. A continuation of the earlier slide, I mean, in case of a business transfer agreement, what are the typical issues which one has to keep in mind? Again, foreign direct investment policy would get applicable or get attracted, provided the end buyer of the business is as a foreign entity or a non-resident parent. Non-compete obligations in this kind of a structure can be enforced provided the structure is designed in such a manner that the entire transaction is shown or kind of structured as a transfer of goodwill. Then you can really have enforceable clauses around non-compete. Successor liability can be excluded. So this is not as loose-ended as a share purchase agreement. And then there are various tax considerations. So in a BTA, which is a business transfer agreement kind of a structure, that there's a tax directly under Section 50B of the Income Tax Act, which is capital gains on a slump sale. So it's considered as a slump sale. And then again, similarly, we need to be cognizant of the stamp duty implications. And one test which is extremely critical while structuring a BTA or a business transfer agreement, the business continuity test. So that has to be kept in mind. And finally, if the business undertaking which is to be transferred is operational for more than 3 years, then long-term capital gains tax would get kicked in, irrespective of whether the individual assets are recently acquired. Next few slides, I'm going to discuss about what e-commerce activity in India is. Basically, e-commerce, as all of us would understand, is buying and selling of goods and services over an electronic and digital network medium. And under Indian law, e-commerce activities would attract three main regulations or laws. One is the FDI policy, the other is the technology law, and the third is the consumer protection laws. Now, under the FDI policy, the e-commerce activity is kind of further divided into two categories. One is the marketplace model of e-commerce, which actually means is where an e-commerce entity provides just a platform in either a digital and electronic network platform and acts only as a facilitator. So I would assume this is something similar to what, say, Amazon Web Services provide in India with respect to its portal. And then there's an inventory model of e-commerce where the goods and services are actually owned by the e-commerce entity and they are directly sold to the buyers. So foreign direct investment is 100% permitted in a marketplace model and not in an inventory based model. This is an important point. Marketplace e-commerce entities are not permitted to influence or have any kind of bearing on the sale price which are listed on their portal, and they must maintain a level playing field. And also, entities which are falling under the marketplace model, if they have any kind of collaboration or an equity participation directly or indirectly, or having a common control with other vendors, then when they provide services to those vendors with whom they have those kind of arrangements, then those services should be at an arm's length basis and should be provided in a fair and non-discriminatory manner. So we spoke about the FDI policy as applicable to e-commerce. Now we'll just quickly touch upon the role of Information Technology Act 2000 on e-commerce. So basically, The IT Act, it kind of validates contracts which are made through electronic means. So what this means is all e-commerce activities need to comply with the IT Act, and especially it has to display and have extremely clear contractual terms in their terms of service and return policies. The second point is quite important. The e-commerce entities must also adhere to the compliances falling under SPDI rules. So what SPDI rules are actually under the Information Technology Act. Sensitive personal data and information rules was introduced sometime in 2011, and I have some dedicated slides a bit later in the presentation to speak about SPDI. So I'll not right now touch upon that point, but yeah, e-commerce entities need to be mindful of SPDI rules. The third important law that e-commerce entities need to be careful about is the recently introduced Consumer Protection Act of 2019 and the e-commerce rules which were under the act formulated in 2020. So this mandates the entities to provide the name and location and a lot of other details with respect to customer care and grievance officers. And also there is a statutory kind of requirement that in case any consumer makes a complaint, then it has to be addressed and responded within a 48 hours time frame. Just give me a minute. So e-commerce rules basically require every entity, which is, I mean, if you are under the e-commerce rules, if you are an e-commerce entity and you are claiming an exemption from any intermediary liability, then you need to comply with certain requirements. So one of the requirements is to obtain detailed reps and warranties from the sellers who are promising the accuracy of the goods and services listed on the portal. Then you have to display, all the consumer-related information, including the details of the seller and the refund policy and the payment terms, etc. And in addition to that, the e-commerce entities have to also comply with India's packaging and labeling laws, in addition to IPRs and employment laws. This is an interesting slide. What is an intermediary liability in India? So intermediary is firstly an entity that kind of provides, or maybe entity that receives and stores, transmits, or provides any service regarding any electronic data on behalf of another entity. So the moment an intermediary falls within the category of a digital intermediary, the IT Act kicks in. And Section 79 of the IT Act clearly exempts an intermediary from any liability with respect to third-party data hosted by such intermediary, provided there are these two conditions which are met. The intermediary has observed thorough due diligence in its duties. That's condition number one. And condition number two is that the function of the intermediary was only and only with respect to providing access to a communication platform without really getting into the modification of the electronic transmission, etc., or without getting into the selection of receivers, etc. So if its function was only to host, and if you can prove that beyond a reasonable doubt, then it can clearly exclude itself with respect to any liability arising with respect to a third-party data being hosted. So these are the two main conditions which kind of are important under Section 79 of the Information Technology Act. Additionally, there were intermediary guidelines which were introduced under the Information and Technology Act, very recently introduced in 2021. it kind of emphasized on the due diligence which intermediary entities have to consider. So these are more inclusive in nature. So I've kind of ironed out two main compliances. So intermediary has to publish the rules and regulations, need to have very detailed privacy policies. They need to have user agreements for access or usage of intermediaries' computer resources by any person. And it also has a right to terminate access to any user who is not complying with the terms and conditions published by the intermediary terms. And in this regard, two cases which I thought I should bring out just from an academic standpoint. One was a case of 2015 by the Federal Court of the Supreme Court of India in 2015, which clearly said that intermediary must take down unlawful content within a span of 36 hours as part of its due diligence initiative. And more recently, in 2020, the Karnataka High Court has ruled that intermediary cannot be liable for third-party listing of contractually banned items. So obviously, these cases would be more fact specific. So I'm not getting too deep into that. I'm not getting into the kind of ruling. We'll quickly discuss about OSP guidelines or other service provider guidelines. So until, I mean, there were other service providers category earlier included all IT-enabled services and data centers and cloud service providers. All of them were categorized as OSP. But more recently, November 5th, 2020, the Indian government kind of introduced new OSP guidelines. The main purpose was to supersede the old OSP notifications and also to kind of liberalize the OSP legal regime in India. And interestingly, the OSP guidelines, which have been introduced in 2020, only regulate voice-based business process outsourcing services. They do not cover or regulate data centers or non-voice based cloud service providers. So these are the two exclusions which have been brought about in the new policy guidelines. However, on September 14, 2020, TRAI, which is the Telecom Regulatory Authority of India, recommended to have an industry body-based approach for regulating cloud service providers. This was more because the cloud services were the next most important technological shift, especially in COVID times and work from home, etc. So these are proposals which were made by the TRAI, and mainly what the suggestion was that if a cloud service provider is an infrastructure, it is kind of hosting infrastructure as a service or a platform as a service, then they need to register themselves with the proposed industry body. And also there has to be a uniform code of conduct prescribing quality of service parameters, with prescribing model terms of service agreements and prescribing detailed data security norms. I've gone slightly in detail on data privacy because I thought this was a very important topic to cover. So, historically, India has always struggled to have a very devoted data privacy law. And the current regime also does not have a very thorough data privacy law. But what we have in India currently is under the Information Technology Act, there are these SPDI rules, which is sensitive personal data and information rules, which kind of mainly covers only sensitive information relating to individuals. It does not protect, and individuals also information which is only exchanged in electronic form. So it does not protect information which is shared in verbal or in written form, nor does it protect data of juridical persons. So currently there is no law as such which covers data privacy with respect to non-individuals or juridical entities or corporates. The main focus of introducing SPDI rules was to protect sensitive and personal data and information of any person. And what would really get covered in the sensitive data information? The passwords, financial information, bank account details, credit cards, sexual orientation, medical history or records, biometric information, and also any information which a body corporate would receive from such person and which eventually gets stored or processed under a lawful contract. So that was the main purpose to have SPDI rules. Now, Indian entities which typically collect, process, or handle sensitive information in an electronic form, they have to follow certain requirements or compliance requirements. And what are those? So they have to firstly collect such information for a lawful purpose. They have to hold that information only until the purpose is to be served, or they cannot hold beyond that. They have to obtain a written consent from the individual or the provider of the information regarding the purpose for which the information was collected and would be used. So there is a significant amount of onus on the body corporate, and one could relate to a foreign, a wholly owned subsidiary of a US parent in India. And if you are procuring information from your employees which fall within the definition of SPDI, then one has to be careful about making these or about complying with these regs. And the entity has to maintain a privacy policy that clarifies what is the type of information that was collected, what is the purpose and the usage, and also need to have reasonable security measures in terms of, or practices rather, in terms of protecting that information which gets collected. In addition to the other compliances, it has to have a very comprehensive information security policy, which has to be displayed on its website under the 2011 regulations of SPDI. It has to take reasonable steps to ensure that the provider, you could read as an individual, of information has the knowledge. So the entity has to make sure that the person who is sharing the information has the knowledge of the fact that the information is being collected, the purpose for which it is collected, and who would be the end recipients of that information. And if the company has engaged or appointed a third-party agency, then the name and details and the address of such agency. So a lot needs to be factored before obtaining any information which falls within the SPDI regime. And in addition to that, the providers of the information are also need to be given the opportunity to check the accuracy of the information. And at any given point of time, if the information is deficient or inaccurate, then they have to be given opportunity to correct or amend as may be feasible. More so, the body corporate or the Indian entity has to appoint a grievance officer who will address complaints or discrepancies, if any, from the providers of the SPDI information from time to time. obtain prior permission of the provider of the SPDI before disclosing. So assuming the Indian entity or the body corporate has obtained the SPDI information, it now intends to disclose it to a third party for any reason. Such disclosure could get exempted in three scenarios. Scenario number one is if there is a prior contract under which the provider of the information has already allowed or conceded to share this information to a third party, or it is a requirement or a legal obligation, or a government agency has under law requested for such information. Then in those scenarios, I think under the law, one can kind of share the information without taking any further consent. Lastly, the concerned entity has to conduct a mandatory audit of security standards every year, as also when you upgrade the entire security standard of the organization. There's a proposed data protection law which I thought might be interesting to touch upon. So basically, I don't think this has been notified as yet, but I'll just very quickly run you through it. So government has been proposing a personal data protection bill for many years now, and they have introduced this bill very recently. So what it intends to do is just increase compliances with respect to data processing, and it mandates data co-location. So what this is that at least one copy of the sensitive personal data would at any given point of time be hosted or be stored in a server or data center in India. It also mandates periodic data audits, maintenance of records of data processing, and data protection impact assessments, and a data fiduciary, to whom goods and services or performance of a contract has to be made. Such person has to obtain consent of the main data principal before using the data principal's information. And in context to the outsourcing industries, the data bill is also applicable if data processing is done in connection with any business conducted in India, or if goods or services are offered to individuals in India. So this is a very kind of a brief overview about the new data protection law. I am not too sure when this would actually become a law, because it's kind of pending for a few months now. Hi, Linda, can you scroll to the next slide? Thank you. So, this entire initiative, data localization, has been a new initiative since 2018. What it really means is it is just trying to promote the data center market within India. And pursuant to the localization norms, there has been a huge uptick in server farms, especially in metro cities like Mumbai, Bangalore, Delhi, Hyderabad, where multinational giants like Alibaba and Amazon have set up their own data centers. So the Reserve Bank of India or the Central Bank of India had issued a circular sometime in 2018 April, which required all payment system providers and payment gateways and third-party vendors, and entities who are involved in the payment ecosystem to store payment data only in India. There was one exception that the localization circular allowed domestic payment data used in a cross-border payment. Such data could be stored in a foreign jurisdiction. And what typically a payment data includes is it's an end-to-end transaction and information pertaining to payment or settlement of transaction, which is kind of gathered and transmitted. So this is kind of a definition under the data localization. And the IT Act, along with the SPDI rules, permit transfer of the sensitive personal data information of any other body corporate or a person in or outside of India only if the transferee ensures same level of protection which is expected out of the Indian entity. So not otherwise. So one has to be slightly careful when you're transferring SPDI information or any confidential information outside of India. You know, the data bill permits cross-border transmission of data only under standard contractual clauses or under intra-group schemes which are approved by the proposed data protection authority. So in other words, data bill disallows the processing of critical personal data outside of India. We'll quickly touch upon the data center policy, which was introduced in 2020, again on November 5th. This mainly has, the entire endeavor is to kind of promote data centers in India, and the whole endeavor was to have single window clearances for setting up data centers, demarcating dedicated land parcels for having data center parks, and there's also a requirement of a plug-and-play model, which typically allows pre-approved clearances for setting up data center parks at a very competitive rates for power, etc. So data centers are typically very power intensive nature of operations. Hence, the key regulations that get triggered are related to energy and environmental clearances. And under this policy, there have been a proposal to have 4 data center economic zones, which would be conducive for both non-IT and IT infrastructure. And the most interesting point here is that data centers would also get covered as an essential service, so that to keep the continuity going, and in terms of especially when there are crises and calamities. Very quick overview. I know I'm running short of time. Under IPR considerations, which a foreign entity should keep in mind is IPR typically in India can be transferred under 3 different structures. One is the stock transfer, the asset transfer, or under the business transfer transactions, as we discussed earlier. But what really is important is to the due diligence when you're doing business with an Indian entity, the due diligence aspects of an IPR. So very quickly, most of the IP rights like patents, trademarks, copyrights are capable of being registered. There are search registries in public domain which can be explored to check, especially if the IP has been registered. But trade secrets and know-how are not registered in India. And so contractually, one has to be a little bit more kind of agile when you're checking on trade secrets and know-how. Registration status, ownership jurisdiction, etc., needs to be checked under various IP statutes in India. Typically, buyers would resort for comprehensive reps and warranties because the central database is not that great. and even the Indian courts, the data is incomplete or not updated regularly. So these are the key important points which companies need to keep, especially when there's a due diligence around IP being done. As far as transfer IP, this is probably the most important slide when it comes to IP. So in a nutshell, I think India work for hire rules are very different than in the US. Typically in India, I'll give you an example. If an employee enters into an employment contract, such a contract is merely regarded as a right to assign the IP in future, but it is not considered as an actual assignment. So what one has to be careful about, that the IP created by an employee does not automatically get assigned to the company. So a separate assignment agreement has to be executed between the employer and the employee for specifically assigning the IP into the employer. And same goes for a kind of a business relationship where a US entity has outsourced its IT services agreement to an Indian vendor, IT vendor, and the Indian IT vendor is either using subcontractors or employees to generate or create software or something which has an IP value. So ultimately what happens is, how that back-to-back assignment happens, the concerned employees will have to assign the IP created by them into their employer, which is the Indian vendor, and then the Indian vendor will have to assign the entire IP rights into the customer, that is a US client. So this is something which not many people have delved into. And this is something which we have been quite pioneers in kind of advising clients, and it's really the interpretational aspect which one has to be a little bit careful about. Linda, next slide, please. Yeah, so moral rights, the law around waiver of moral rights is not really settled under the Indian law. So that is the point number one. And mainly, under Section 57 of the Copyrights Act, the moment the author creates something which is copyrightable, the author becomes the owner of such work. And the author also has a right to restrain or claim damages in case that particular work gets distorted or it kind of causes prejudice to the author or to his honor or reputation. So this was the point, that anything which is created has to be formally assigned. And another important point here, which one has to be a little bit careful about, is the right given to the author under Section 57 would even subsist despite there is a partial or whole assignment of the copyright. So this is something we need to be clear about, and it's pretty much in terms of practice, there is a standard practice to include a waiver clause in respect of moral rights in deeds of assignment, although as I mentioned, the law is not very completely settled under the Indian law. Typically, a buyer would call for representations and indemnities from the seller with respect to any claims arising under Section 57, because the copyright which is getting transferred, there could be a claim around that. So always taking a reps and warranty or an indemnity is advisable. With respect to competition law considerations, I just have 2 points to make. In India, typically enterprises or businesses are kind of prohibited from entering into agreements which are anti-competitive. So agreements causing appreciable adverse effect on competition within India are completely prohibited. And there's also a prohibition applies if the agreements, irrespective are vertical agreements or horizontal agreements in nature. And then prohibition would also apply to practices such as price fixing, production control, collusive bidding, etc. And the second element is, especially if an entity is in a dominant position, and if it tries to abuse its dominant position, then there's a embargo or a prohibition. So what would typically be the cases? Imposing discriminatory conditions in the purchase or sale contracts, or trying to limit or restrict the production or the provision of services, or with respect to goods or services, or indulging into practices which would result in denial of market access to a third party to enter, or trying to use dominant position in one relevant market to enter into another relevant market. So these are some of the abuses of a player who may have a dominant position in India, and that is completely prohibited. So that kind of brings end to my presentation on the key current issues relating to outsourcing in India. Thank you. Thanks for hearing me patiently.